you've got a signed contract. Everyone's excited to close. Then we start reviewing ownership and discover that the property isn't owned by an individual. It's owned under a trust, LLC, or even a estate. So who actually has the authority to sign? Today, we're breaking down one of the most common causes of unexpected closing delays, determining who actually has the authority to sign. Ownership and authority are not the same thing. This is where many transactions hit an unexpected speed bump. People often assume that if someone lives in the home, pays the taxes, or is handling the sale, they must have the authority to bind and convey. But we don't actually look at who lives there. We could care less. We look at who legally owns the property and who is authorized to act on behalf of that owner. And those aren't always the same person. In fact, some of the biggest delays we see happening because everyone assumed the right person was signing, only to discover they weren't. Takeaway: before you list a property, ask, how is title currently held? That little question can uncover potential issues months before closing. Trust-owned properties. Let's start with trust, because this is something we're seeing more and more, especially here in Florida. A trust is a fiduciary relationship between a trustee, a settlor, and a beneficiary. A trustee is an individual or entity appointed to administer assets for the benefit of a third party or beneficiary. The settlor is the person who creates that trust. Beneficiary has a present or future interest in a trust. The trustee, not the trust, holds legal title to the real property, and the beneficiary holds equitable title. There can be more than one trustee, settlor, or beneficiary. Many homeowners place their property into a trust as part of their estate planning strategy. When this happens, title to real property should be vested in the trustee of the named trust rather than the trust. For example, John Smith as trustee of the Smith Family Trust, dated October 24, 2022. At common law, a trust was not recognized as an entity with the legal capacity to hold title to the land. And here's when you need to be careful that you're dealing with the right person. The only person that can dispose of the asset is the named trustee. If you're dealing with anyone else, please contact your favorite closing company as further steps need to be taken. Real life scenario. Imagine 3 siblings place a property in a trust. All 3 beneficiaries agree the house should be sold. But if only one sibling is serving as trustee, make sure you're dealing with that trustee, because that trustee is the only person authorized to sign conveyance documents. Takeaway: when a property is held in a trust, identify the trustee early, not the week before closing, and you're gonna save headaches and pains. LLC owned properties. Another ownership structure we encounter frequently is limited liability companies, or LLCs. Investment properties, rental portfolios, and even primary residences are increasingly being held under LLCs. To form a Florida LLC, one or more authorized representatives must sign and deliver the articles of organization. Florida or foreign LLCs may own, sell, or mortgage Florida real property. In addition to the articles, the LLC may enter into an operating agreement regarding the affairs and conduct of its business, which will always prevail and provide the authority of the parties that are able to bind the entity. And this is where assumptions can quickly create problems. A seller might say, "I'm one of the owners." Well, that's great, but being an owner doesn't automatically mean you have authority to sign. Why? Some LLCs are manager managed, others are member managed. Some operating agreements require specific approvals, and some LLCs have changed ownership over the years without updating records. Example: we've seen situations where a realtor spent weeks marketing a property only to learn later that the person signing the contract wasn't actually authorized to sell the property. Takeaway: don't ask who owns the LLC. Rather, ask who has the authority to sign on behalf of the LLC. That's a very different question, and it's gonna get you a very different answer. States and deceased owners. Perhaps the area where we see the most confusion involves estates and deceased owners. A property owner passes away. The children decide to sell. They assume they can move forward immediately, but that's not always how it works. The reality: just because someone is an heir doesn't automatically give them authority to sell real estate. When an owner passes away, depending on how the property was title, there may be additional items or processes required. For properties held as tenants by the entireties or joint tenants with rights of survivorship, the surviving title holder may be able to sell the property by just producing a certified copy of the decedent's death certificate. However, properties held as tenants in common, probate proceedings are required, whether or not that decedent had a will. Picture this. Imagine you're 3 weeks from closing. A property held under two married individuals is being sold. The title company discovered one of the owners passed away. Upon review, the married couple didn't specify in their deed that they were married to each other. In this case, a tenancy by the entireties may not be created, and therefore the law presumes that they were tenants in common. That will completely change the timeline and picture for closing, because now a probate may be required. Takeaway: states should always trigger additional questions upfront. When purchasing under a specific tenancy, make sure the deed shows the desired vesting accordingly to save headaches in the future. If it's husband and wife, make sure it stays husband and wife. If it's joint tenants with rights of survivorship, make sure it states that on the deed. Take care. So how do we verify authority? So whether we're talking about a trust, an LLC, or an estate, the same question keeps coming up. How do we actually verify who has that authority to sign? The answer is simple: documentation. It's one thing for someone to tell us they're the trustee, manager, personal representative, or an authorized signer. It's another thing to have the documentation that supports it. And this is where we often see delays occur. Not because there's a problem with the transaction, but because the necessary documents haven't been gathered or reviewed yet. For example, if the property is held in a trust, we may need documentation confirming who the current trustee is. If it's owned by an LLC, we may need to review organizational documents or operating agreements to verify who has signing authority, or if we need a resolution. If the owner has passed away, there may be probate documents or court-issued paperwork that can establish who can legally act on behalf of the deceased or the estate. Why this matters? The challenge is that these documents aren't always readily available. Sometimes they're outdated, sometimes they're incomplete, and sometimes no one realizes they're needed until the transaction is already well underway. Takeaway: this is exactly why identifying trust, states, and LLC early is so important. The sooner title is aware of the ownership structure, the sooner we can determine what's needed and avoid last-minute surprise. Because more often than not, it's not the ownership structure itself that delays the closing. It's waiting on the documentation needed to verify the authority. The question that can save you weeks. If there's one thing realtors should take away from today's conversation is this: before listing a property, ask, how is title currently held? Is it held by an individual, a trust, an LLC, an estate? The answer can determine everything from who signs documents to whether additional paperwork is required. Trusts, states, and LLC don't have to complicate a transaction, but they do require a little extra layer of verification. The sooner the title company knows how a property is held, the sooner we can verify the authority, identify potential issues, and keep your transaction moving towards a successful closing. A quick conversation at the beginning of the transaction can prevent major delays later on. Because at the end of the day, one of the most important questions in any transaction isn't who wants to sign, it's actually who can sign. Follow us on Instagram and subscribe to our YouTube channel for more valuable insights that will keep you closing and closing.